Thank you again for tuning in to our Retirement Education Center YouTube channel, where on this channel what we believe in is providing you unbiased advice to help you maximize all of your retirement income. Now on our channel, we don't believe in providing you with any type of silver bullet strategies, and we certainly do not believe in glorifying any one type of product. But what we do believe in on our channel is providing you with holistic concepts that would help you retire with confidence. Now today on our channel, what we're going to be discussing is the Secure Act and the impact that it is having on inherited IRAs. And so if you are a beneficiary and you're not a spouse of an IRA, if you're the beneficiary of an IRA, you're going to definitely want to stay locked into this channel today, as we're going to talk about the Secure Act and the impact that it is having on inherited IRAs. So stay locked in. Hi, my name is Carson Graves, President and CEO of the Retirement Education Center.
And my name is Andrea Graves, Director of Operations at the Retirement Education Center. And we want to thank you for tuning in to our Retirement Concepts videos. These videos are created to help to make the difficult and confusing retirement process simple.
Absolutely, Andrew, because with so many retirement concepts out there, so many retirement strategies, and of course so many retirement products, it can become very difficult for consumers to digest it all. That is why we're so fortunate to work with a team of expert advisors to help us build a financial roadmap that will let our clients know when, where, and how they can reach their retirement goals.
For additional concepts on how to maximize your retirement, please subscribe to our YouTube channel and hit the notification bell to be notified when we upload new videos. Carson, the passing of the Secure Act took effect in December of 2019, but the changes took effect in 2020. Could you tell us more about that?
Yeah, absolutely. The Secure Act, by the way, Andrew, they have the Secure Act 2.0 that we are going to be discussing in another video. We're going to talk about the details of that, which is going to also make a huge impact for retirees. But the Secure Act 1.0 has already made a huge impact, right? I mean, they've now push back the age for your required minimum distributions. It used to be 70 and a half, and of course with the passing of the Secure Act, that is now going to be age 72. Now the Secure Act 2.0 is going to make some even more substantial changes to the required minimum distributions. But with that being said, one of the major impacts of the passing of the Secure Act, Andrew, was how inherited IRA distributions were treated. And so we are going to talk about that in today's educational concept video. But before we get into that, there are always two rules to retirement income that we like to give you. And Andrew, what are those two rules?
Well, rule number one is to never run out of money, and rule number two is to never forget rule number one.
All right, so let's go ahead and talk about the Secure Act and how it is impacting inherited IRAs.
Carson, is an IRA going to a spouse treated differently than going to kids under the Secure Act?
Well, Andrea, of course, before we talk about the differences here, it is important to understand a terminology known as an eligible designated beneficiary. So if you're an eligible designated beneficiary, you do have some benefits that other non-eligible designated beneficiaries would have. So an eligible designated beneficiary would be someone like a spouse, or it would be a kid under the age of 18, someone who's chronically ill, or someone who's within 10 years or younger of the IRA owner. If you do fit that category, Andrea, you are still able to stretch that IRA out over your life expectancy. So you don't fall under the new Secure Act rules. Now, when it comes to an eligible spouse, they have the most flexibility. So if you're a spouse and you're receiving an IRA, what you can literally do is keep that IRA as an inherited IRA, just like anyone else would. Because if you're younger and you need some financial support, that may be a huge deal for you, because you can avoid that early 10% withdrawal penalty if you're under the age of 59 and a half. Now, if you are a spouse, Andrea, and you receive the IRA from your deceased spouse, well, you can also roll that IRA over into your own IRA, and you would not be required to take any required minimum distributions until you reach the age of 72. So, Andrea, what you would do as a spouse of the owner of that IRA, you would have the opportunity to stretch that IRA out longer, grow it, of course, a lot longer, and not be required to take any required minimum distributions, whereas other beneficiaries would not have that particular option.
Carson, what about those sticky situations on a second or even a third marriage, and you want to make sure that your kids get their fair share of, their beneficiary amounts?
Yeah, that can happen all the time, right? Mm-hmm. You can be someone who's in a second marriage, and of course you have kids from a prior marriage, and you want to make sure that those kids get fair amount from that IRA, and you want to make sure that the new spouse, if you pass away, they're not just able to name beneficiaries of those dollars that you're trying to leave for your kids from a prior marriage. Now, if this is the case, Andrew, I would highly recommend that most people sit down with an attorney and develop a trust, a conduit trust that they can set up to make sure that the required minimum distributions from that IRA can still go to the spouse that is left behind, and make sure that they are still adequately taken care of, but making sure that trust also states that anything that's left over into that IRA will go to their kids, their kids from the prior marriage. So I would highly recommend that if people have the fear that the new spouse will not appropriately, have those funds allocated to their kids that they want those funds to go to, sit down with an attorney, set up a conduit trust, to make sure that you outline exactly what you want those dollars to do.
Carson, what should non-eligible beneficiaries be aware of?
Yeah, Andrew, we talked about, eligible designated beneficiaries, and now we want to distinguish between the non-eligible designated beneficiaries, because that is a big difference, and that's where the Secure Act really has made a huge impact. And that's going to be someone who's not a spouse, someone who's over the age of 18, someone who's not chronically ill. That's going to be a non-eligible designated beneficiary. Now, in this circumstance, Andrew, you have what we call the 10-year rule. Andrew, this year the IRS recently came out with a ruling known as an at least as rapidly rule. So I'm going to say it again, at least as rapidly rule. That's the rule that the IRS has come out with. It couldn't have been more tongue twisting, right? But that's the rule that they've come out with to this eligible designated beneficiaries. So with this rule, if you receive an IRA and you are actually a non-eligible designated beneficiary, if you receive that IRA, they are going to require you to start taking required minimum distributions based off of your life expectancy if that owner of the IRA had already started taking their required minimum distributions. So if you are, let's just say you're 45 years old, Andrea, the IRA owner has started taking their required minimum distributions, you're going to now be, you're going to be mandated to start taking required minimum distributions based off of your life expectancy. But here's the thing, by the end of the 10th year, you have to have extracted all of those dollars out. So you can take it out over your life expectancy based off of your life expectancy according to the IRS tables, life expectancy tables. You can do that. But by the end of the 10th year, you do have to have all those funds out, which is pretty consistent with both of the rules that we're talking about here. Because in the other circumstance, if you actually receive the IRA and the owner of the IRA was not taking their required minimum distributions, you do not have to start taking those required minimum distributions right away. But nevertheless, you still will have to have all those dollars out within 10 years. So the common theme around the Secure Act is that within 10 years, no matter what the circumstance may be, you have to have all those funds extracted out of that IRA. You have to have pulled all of those funds out, paid taxes on those dollars from that inherited IRA. But the at least as rapidly rule is a little bit different, right? If they've started taking their required minimum distributions, you have to immediately start taking required minimum distributions based off of your life expectancy. If they have not started taking their required minimum distributions, you just have to have those dollars out within 10 years. I know that it's very confusing. They keep changing these rules, and I understand that, but that is why we implore you to give us a call or someone who is qualified to help you understand these rules so you do not make a mistake.
Carson, thank you again for your insight on this topic, and thank you for watching. And if you felt this information was beneficial for you, please like and share with others.
So I really do hope that this information that we shared with you today provided you with some insight on what you should do in case you actually inherited an IRA. Please remember that these videos are created for educational purposes only, and that you should always seek out your own financial advisor, your own tax advisor, and your attorney regarding your personal situation. Also, if you are looking for a fiduciary financial advisor to help you with these types of complex financial matters, we highly recommend that you utilize the links provided in the description below and go ahead and schedule a 1-hour free consultation with us today.
For more information on this topic or any of the other topics that we've shared in our other videos, feel free to reach out to our office or leave any questions or comments in the section below. After this video, please check out our other videos that we've created that will give you tips on how to maximize your retirement. And if you like this video, please give it a thumbs up, subscribe to our YouTube channel, and share it with a friend. Thanks for watching, and remember, if you have questions,
we have answers.